When can involuntary commitment happen for someone with PTSD? Imagine a person with post-traumatic stress disorder suddenly acting in ways that threaten their safety or the safety of others. Involuntary commitment is a legal process that can happen in such situations, but only under specific circumstances. It is designed to protect individuals and those around them when their mental health condition causes serious danger or prevents them from caring for themselves. Involuntary commitment can occur when a person with PTSD has a diagnosed mental illness and is showing signs of immediate risk. This includes behaviors like suicidal thoughts or actions, threats of violence, or violent outbursts that could harm themselves or others. If someone is in a psychiatric emergency, they can be taken into custody and admitted to a mental health facility without their consent. This is called emergency commitment. However, this is not indefinite. A court hearing must follow quickly to decide if continued treatment is necessary. The second situation is called judicial or non-emergency commitment. Here, there is no immediate danger, but concerned family members, healthcare providers, or others believe the person needs treatment and is unable or unwilling to seek help voluntarily. In this case, a court can be asked to evaluate the person's condition. The court reviews evidence, including medical opinions, to determine if the person meets the legal standards for commitment. The key legal criteria include that the person has a mental illness, which includes PTSD, and that they pose a substantial threat of harm to themselves or others. It also includes cases where the person cannot meet basic needs like food, shelter, or health care because of their mental state. The law requires that less restrictive options, like outpatient treatment or community support, are not enough to keep the person safe. In the context of PTSD, involuntary commitment might be considered if symptoms lead to severe impairment such as suicidal thoughts, self-harm, violent behavior, or neglect of self-care that threatens their safety or well-being. It is important to understand that involuntary commitment is meant as a protective measure, not punishment. The goal is to provide necessary treatment to stabilize the individual and prevent serious harm. Courts and medical teams aim to use the least restrictive setting possible and always respect the person's rights. This includes holding timely hearings and providing ongoing oversight to prevent unnecessary or prolonged confinement. Laws and procedures vary by location, but all follow principles of due process, ensuring the individual has a chance to be heard and their rights protected. From the perspective of someone with PTSD, involuntary commitment can be very distressing and may feel like a loss of control. Still, it is a legal safeguard meant to help when someone cannot seek help on their own. Connecting with community resources, emergency help, and support systems early can often prevent situations from escalating to the point where involuntary commitment is needed. Encouraging voluntary treatment and early intervention is always preferable, helping individuals regain stability and safety before crises develop. In summary, involuntary commitment for someone with PTSD can happen when their mental health leads to immediate danger or prevents them from caring for themselves, and when they refuse or are unable to seek help voluntarily. This process involves careful legal and medical evaluation to balance safety, treatment needs, and individual rights, always aiming to provide care in the least restrictive way possible.